The writ of possession is at the very end. All of this starts with one, in the case of rent not being paid, the rent isn't paid. There's some communications going between the landlord and the tenant about, hey, where's my rent? And then you get this notice to vacate. And then once you don't vacate, the landlord can go and file a summary ejectment proceeding, which is another way of saying filing a court case against you, saying you owe me this money, you have not paid your rent, I want you evicted out of my property. And usually that's going to be in small claims court before a magistrate.
Well, your rent notice is basically a magistrate summons with a complaint and summary ejectment attached to it. That comes from the clerk's office to the sheriff's office, and what that is basically the notification for the hearing for the landlord to start the procedure to get their property back. We'll receive those from the clerk's office. The deputies will take those, and they will attempt to make contact with the defendant or defendants that's listed on the magistrate summons. If we can't make contact, we will post, as statute allows, for the court date. And once that is returned, they have been served for their court date. Once we've served it, they'll have to call the court. If they don't understand something about it, that would fall more under calling the clerk's office to find out if there's any discrepancy about the court date or if there's any problem that they may have with the court date. They would need to contact the clerk's office because we're actually just serving notice of the court date.
That's the first part where we're involved. Only thing we're doing is serving the paperwork just like any other lawsuit. Then you go before the magistrate, the landlord presents evidence, you can present evidence, or the renter can present evidence, a decision is entered. You have a right to appeal that decision to the district court. If you appeal it, there's some procedures involved with that. And then if you lose that appeal, or if you don't appeal it or contest it, what you're going to have is a judgment being entered against you, and that's when the writ of possession comes involved.
Once the sheriff's office receives the writ of possession for real property, the first thing that's done is a notification will be sent out of the date of the eviction to the defendant or the defendants. Second thing we do is we're going to notify the plaintiff of the date and time that we'll be out there to facilitate the padlock. Once the deputy arrives on scene, the property will be taken from the defendant, turned over to the plaintiff. The defendant will be served the paperwork if they're there, but we're there to take custody of the property from the defendant and turn it back over to the plaintiff as the court has ordered.
Really, the legal process is the entire court case before writ of possession is requested by a landlord and delivered to the sheriff for execution. Writ of possession is basically carrying out the judgment of a court. Just like if you were sued for a motor vehicle accident or some other small claims proceeding, when the judge enters a decision, it becomes a judgment, and then you go collect on the judgment. And then once it is issued by the clerk of court, it's delivered to the sheriff for execution. The reason why the sheriff's office is involved is because when someone is moved out of their property, it's a very tense situation, and the sheriff is involved to make sure that it's a peaceful transfer of property.
As in all civil process, the sheriff's office is just enforcing the court order. The court order is that the plaintiff is to receive their property back. The deputy will go out there, the property will be taken out of the defendant's possession, placed back with the plaintiff as the court has ordered, and we're there to also make sure that that's a peaceful transition during that process.
But the law requires the sheriff to do this, and in fact, if the sheriff doesn't do it, he could be sued. So you should really take some steps right at the beginning of all of this when you first have difficulty with paying your rent. Because when it gets to the sheriff's office, it's too late. So what can you do? In several communities throughout the state of North Carolina, including Durham, there are rent assistance programs. North Carolina, along with the United Way, has developed what's called NC 211. If you pick up the phone and dial 211, you're connected to a resource hotline, and you can tell them what your problems are, whether it's paying rent, paying your mortgage, making utility payments, need of food, and they can connect you with resources in your community. Here in Durham, you have the legal clinic at North Carolina Central. You may also have law clinics over at UNC, Duke, over in Raleigh at Campbell, where you can get some free legal advice. You have Legal Aid of North Carolina, but if you go to their website, they have literature on there on what the eviction process is, what is a summary ejectment, what you should present to court. Can you get out of it? Can you pay your rent? Can you settle this? What to do if you want to get into a settlement. Here at the Sheriff's Office, we know about the process, but we can't give you legal advice. State government is well aware of the effects of the COVID-19 pandemic on individuals, and so there's some relief efforts being made. And so really what I'm saying is that the solution to a lot of this is before you get to the writ of possession. There are community organizations out there that will help you with rent assistance. The General Assembly, which is our state legislature, is looking at some solutions. Our local officials may be looking at some solutions. Churches may be available. So when you get into that situation of not being able to pay your rent, making utility payments, not being able to put food on your table, oftentimes we panic, we become concerned, and that is the moment where you don't close yourself in. That's when you need to go ahead and ask for the help that may be out there, because if you act quickly and at the beginning of the process, you won't get into the court system and you wind up staying in your home. Because by the time it gets to the sheriff's office with the writ of possession, there's not much, if anything, that can be done, and our hands are tied.